The short story is I've had a wonderful career at a number of law schools, and almost exactly they've been divided into two parts. Meaning I've spent a number of years as a law school dean, as you mentioned, for a little over 6 years at Northwestern Law School until a year and a half ago, and in a previous lifetime as the dean of the University of San Diego School of Law. And I've just been privileged to serve as dean at those two schools, and very proud of what I and my colleagues were able to accomplish. And I've spent an equal number of time as a civilian law professor, as it were, as a legal scholar, teaching and writing in a variety of areas in reverse chronological order at Northwestern, and before that at the University of Texas in Austin and University of San Diego. And I began my academic career at University of California at Berkeley in California, which is where I was born and raised. I would simply make sort of 2 points, if I may, by introduction. One is I alluded to my visits in Mexico City. Both for me personally and professionally, and also for Northwestern, we have cherished and continue to cherish our relationships with our colleagues and friends in Mexico. Pepe, I don't want to embarrass you too much, and you're probably known to this audience, but as a graduate of our law school and the personification of the partnership and the relationship that we have throughout Latin America and Mexico in particular. That is ranges from the LLM students and JD students and Master of Science and Law students who come to us from Mexico. It also includes relationships with key law schools there in the area. I'm not going to name them all, but I want a special shout out to our friends at ETAM Law School, which I've had the pleasure to visit a number of times since I've been down there. So very, very important. Once a dean, always a dean. So I have to have my dean's hat on in saying that Northwestern has really enjoyed and cherished its connections in Mexico City. And the second, I'll say even more briefly, you mentioned, Pepe, in your introduction, my interest in the law and technology and business interface. That's an intellectual interest, to be sure, but it's also a prediction about the future that I know we'll get into in this presentation. And that is to say, a prediction that law students, whether in the United States, in Mexico, and throughout the world, must need to understand the connections between what they're doing as lawyers, as future lawyers, and also what folks in the business sector and the technology sector are doing, and working on integrating those fields and those areas has been a very significant preoccupation of mine and so many others. And so happy to talk about that in the conversation. That's plenty about me. for now.
Perfect. That's amazing, Dan. So before we start with the webinar, guys, I just share Dan's information. He's very active on Twitter and on LinkedIn. You can follow him. I just copy on the chat his Twitter and LinkedIn profile. And also, before going further with this webinar, I will ask you that just keep the mic on mute, please, so we don't have any sound on the background. We're going to have a Q&A question at the end, but if you have any question during Dan's presentation, please put it on the chat so we can go to every question at the end of this webinar. So Dan,
Okay.
The mic is all yours.
Great. And while it's mine, I am trying to do something simple, but it's not so simple, but I'll figure it out. And that is share with you a not particularly technologically compelling PowerPoint presentation. Don't get your hopes up. There are not many bells and whistles or great insights to be found, but just as a way of maybe an outline to organize our discussion. So I was invited to talk with you, and I immediately offered a rather pretentious title, admittedly so, New Strategies of Legal Practice for New Times. There's a very large number of you, maybe all of you on this who are joining us could talk about that, perspectives about legal practice and technology. But the world has changed to make a banal point. The world has changed in profound ways over the last few weeks and months. And so what I spend a lot of my time thinking about, as I know you all spend a lot of time thinking about, is how the world is changing with respect to lawyers and lawyering, legal practice. It's one thing we think about. We think about much else as well. And how we can be intentional about that. So when we just think of the phrase, how the world is changing, sounds like something that's happening to us and washing over us. But that's not really captures the point, right? The point is how those of us who are in the legal space, whether we're practicing lawyers, academics, those who use law as clients, can use this occasion. Let me rephrase that. That's not really the right way to put it. How we can, in living our professional lives, mobilize and use technology and other resources in order to not only deal with the profound public health crisis that we're in, but also utilize the tools and the education we're giving to enrich life through the use of law. So I want to talk a little bit about the use of technology in the practice of law, a perennial topic, but try to ground it to some more or greater or lesser degree in the crisis that we're in. And so with that, new technologies wide. Now I will come to COVID-19 and the topic, but I want to do that through this prism and talk just for a few minutes about from sort of a 10,000 feet perspective of how we think about lawyers and legal professionals utilizing technologies. So why would we do that? So this is a sort of a homely description, if you'll permit me. Well, why bother using new technologies in the practice of law? I think there's a lot to put under these bullet points, but let me just leave it at this. To help with ordinary legal practice issues. I should have put ordinary in quotations because that may be a little, what is ordinary or extraordinary may be in the eye of the beholder. But we can think about, any lawyer ought to agree at least on this, right, wherever they find themselves in whatever country, is that technology's use and its reliance very much depends on whether and to what extent we can use technology to provide more efficient legal services and hopefully also provide greater access to the justice system, right? That's in our interests, it's in the collective interests, and it's certainly in the interest of our clients. It should also be and is consumer driven or client driven, if you prefer that, and that is we utilize or ask to utilize technology in order to open access to justice, and if I may be permitted an overly florid comment, to democratize law, right? To make available law, and to make that a little more concrete. So why widen access to legal information, which is I would suggest it's an imperative. Others might say it's at least an objective and a goal to make legal information more widely accessible. At some level, that is not merely an efficiency imperative, but an imperative of democratizing law to make it more available and more accessible. I'm going to say some things a little more radical than that. You'll be happy to know, but that is just to make a broad point about how we might think about using technology and why. And so this is an expression, I don't know how well it translates to those of you for whom Spanish is your first language, and I'm not going to try to do that. My Spanish is inadequate for that purpose. But in English, we often hear the expression, with an available hammer, everything looks like a nail. And what I mean by that is, one answer to why we use technology, not a great answer, but an answer nonetheless, is we have it available to us. And if we have these neat and nifty tools, then those tools ought to be deployed in order to provide value. And I want to suggest that that's actually not the best answer. And we need to think about not only the efficacy of technologies, but the reasons why we're using them and why they might enrich and enhance legal practice. New technologies, what? This is impossible, of course, to put on one slide, and I wouldn't even pretend to. I'll just hit three, if not highlights, then three areas in which we know the technology. New or newish technologies are being used in the areas of legal practice. This might seem like a fairly mundane example, but I would be remiss, particularly with my colleague Dan Linna, who will be mentioned later in this presentation, by the way, just just to be clear about that. I would be remiss if I didn't mention that, we use technology, I call it here software as a stand-in order to help lawyers manage their workflow. So the phrase du jour is project management. If you prefer a different phrase, that's fine, but just think about the use of technology to manage everyday professional life of a lawyer. We have available technologies that enrich our ability to do that. So why the heck not use them? Legal search is a topic we could go off on a long tangent on that. In the interest of time, we won't. But if you think about, just take a time frame from when I started law school. That's fairly random, but yes, that's gulp, quarter century ago, a little bit more. Legal search in the form of Lexis and Westlaw was all the rage. In fact, through very creatively and shrewdly, both Lexis and Westlaw got their hooks in us as law students by providing their technology basically for free in order for us as newly minted lawyers to come to rely, to get hooked, as it were, on that kind of information. So that became, and really was sustained for a long time, sort of first generation legal search with the technology that was available at the time. I like to think of the second generation as not that long ago, as the advent of Google and the development of various algorithms, technology enabled to allow us to do search more efficiently, borderline for free in some ways. That's destabilized the economic model. And the third generation is what's yet to come, right? The development of legal search. But here's where we're sort of hungry for information, and it's altogether a sexier topic, and that's artificial intelligence and machine learning. Now, these next two slides, I don't want to get sued, so I want to say these are stolen directly from Dan Linna, Professor Dan Linna's slide deck. So he will recognize them. I didn't even ask for his permission. So, but there's an old saying, easier to ask for forgiveness than for permission. So here's one. And that is, Professor Linna, you recognize this slide. This is in a nice graphic, the kind of the iteration or the evolution of machine learning and artificial intelligence, just to make clear what we mean or what we don't mean when we say we have artificial intelligence available as a technology. So it's probably too small to read, so I'll read it for you. So artificial intelligence, we can say as good a definition of any is the engineering of even I can't read it that well, making intelligent machines and programs, right? Making intelligent through artificial learning. Machine learning, the ability to learn without being explicitly programmed. And then there is the wild, wild west, or the frontier, choose your favorite metaphor, the prospect of deep learning, right? Artificial intelligence that's not rule-based, but can really develop and learn from itself. I think it's fair to say, and I suspect most would agree, that we're somewhere in the middle part of this slide in the current iteration of artificial intelligence in the practice of law. Folks quarrel about this, and frankly, I find this utterly uninteresting to me. I'm not a computer scientist. I don't play one on TV. About whether or not what we're using with respect to machine learning now should even be called artificial intelligence, right? Should the use of algorithms that are very much built around settled rules and develop outcomes through sort of logical sequences, much like, for example, when you go onto Amazon and order stuff, as we still do, maybe even more so in this shutdown period, and they say, oh, if you like this, you'll like that. Or if we order from Netflix our TV shows, and only to find that they recommend these shows for our viewing, that's a rule-based system, and we certainly come to understand that in various ways, and we utilize that in the practice of law. But what we don't know, and we truly don't know, is what's next with respect to the development and the use of artificial intelligence. Again, the applications of AI, artificial intelligence, and machine learning are underway. We see that in areas of e-discovery and diligence, due diligence, and other areas of law, which certainly we can talk about, in compliance, and also in quantitative legal prediction. I think it's fair to say, just as a footnote or as an aside, an entire field that's really developed in the last few years, litigation finance, which is not unique to the United States, right? It has gotten a foothold, or a toehold at least, in a variety of countries, has been built up and is enabled by the availability of big data, and along with it, the ability through the use of technology to access and utilize that data in order to generate legal predictions. And that's what litigation finance is about, right? Putting their money where their mouth is, having the companies invest in litigation based on their comparative advantage of knowledge that they have and they can develop and utilize, right, about predictions of the outcomes of cases. So the development of quantitative legal information, development of big data in order to yield information to allow us to make predictions is not only the frontier of the use of technology, it's here before us. And so most of us who study legal innovation and legal knowledge pay homage to Richard Susskind, who is not the former Richard Susskind, the current Richard Susskind, who is both alive and well and hard at work at not only making predictions about legal innovation in the future, but about really telling stories about how legal technology can be utilized in very important ways. Most recently, by the way, in a wonderful new book about the future of online courts, which, having spoken to Richard, he didn't realize even how timely it would be until the current crisis was underway. And so I just give you this again in a slide swipe from Professor Linna, a quotation, extended quotation from Richard in this area. So it's more time I wanted to spend on that, but that just sets a broad table, at least, of why we might use technology and how technologies might be utilized with respect to legal practice. It's next to the last slide on that. When we consider how we use these particular technologies, I want to make this point. I'm not the first point to make it, first person to make it, nor will I be the last, but let me make it nonetheless. It's important to consider, this goes to every hammer, if you had a hammer, everything looks like a nail. It's not the right approach. We need to identify the problem that we're looking to address and solve. Keep our eyes on that prize by thinking about the use of technology is about enabling us to solve problems. And in the area of law in particular, to solve our clients' problems, to solve consumers' problems, rather than look at technology as, let's utilize the bright, shiny object that's available to us, because technology is ubiquitous and available in a variety of forms. And I won't go into many of these examples. I'll just mention one, since I mentioned Richard Susskind a moment ago. So take, for example, online courts. In a nutshell, we have now the technologies available to do an enormous amount of new kinds of things with respect to adjudication in the civil and in the criminal justice system. Nothing unique to the US with respect to that. On the contrary, there are some areas, parts of the world, British Columbia, for example, in Canada, that has utilized a technology to provide access to online courts. Certainly some parts of Europe. Brazil, which has an enormous and a massive we all do, right? But Brazil uniquely has a massive backlog of cases, and they've utilized online techniques in order to do adjudication. The technology is extraordinary. The question, though, the question at the heart of this, and Richard gets into this in his book, is how far we are willing to go down that road. Will we, for example, delegate significant amounts of dispute resolution to algorithmic decision making? We say robots almost as a stand-in in some particular ways. We have the technology to do that. There are enormous efficiency advantages to do that. But as Richard and others have observed, and I'd make this point as well, there are issues of fairness, there are issues of culture, there are issues of due process in the American and also in the foreign context, however it's called and framed, that raise serious, even existential questions about the utilization of technology. And those questions need to be resolved, if not simultaneously, if not before, than simultaneously with the use of those particular technologies. So there are enormous questions on the how side about how technology is utilized. All right, let me turn the page, as it were, and spend just a couple moments, again, in the interest of time, not to dwell on this, because I really want to get to some of these issues that are impacted by COVID-19. But I promised to say a few words in the teaser for this webinar about regulation, and here I want to make it say this now. We are in a period in the US and abroad of serious interrogation of the structure of regulation of legal services. When I say that, I want to be clear, I'm engaging not only in an empirical description of the state of the world, but also, frankly, in some wishful thinking. We are in a period of reflection, and I want to suggest we ought to be in a period of even more systematic reflection on the regulation of legal services, where it works, where it doesn't work, where it succeeds, and where it fails. And here's some examples. Again, generalizing across the world, not making this just about what's happening in the United States, even though, frankly, I know more about what's happening in the United States than I know elsewhere, about what kinds of interrogations are underway and how we're looking at regulation. One has to do, this is a loaded phrase, I admit it, with the lawyer's hegemony or lawyer's monopoly. That is how we draw the lines between legal services that only licensed and credentialed lawyers can provide and legal services that can be provided by others. And by others, I mean, I hate to use the phrase non-lawyers, since that reveals really nothing of interest, but allied professionals, paraprofessionals, paralegals, individuals in the business sector, a variety of folks who all share this in common, this one thing in common. They do not have the credential under the licensing system in whatever system to be called a practicing attorney. Now that's circular, of course, right? Because what obliges a system to limit access to legal services to only those who are credentialed as lawyers? The answer is the regulatory structure and the regulatory system. So that we're seeing undergoing a fair amount of tension and interrogation, even in the United States. I say even in the United States because we have a very protectionist scheme in the US, right? And to make matters even more complicated, we have 50 different states, and they all have their own rules and regulations governing that. But that's going under some interrogation. We are seeing some interrogation, and here I really am engaging in some amount of wishful thinking about borders and boundaries. And I'm referring here again to the phenomenon of the 50 different states all having their different rules and regulations. Some of you know this on this webinar. It's extraordinarily difficult to move from one state to the other as a practicing lawyer. I don't mean literally to move, but I mean practically to move. Having to take a whole new state bar exam, the restrictions on waiving in and reciprocity are extraordinary and extraordinarily anachronistic in my view. And it comes into sharp relief during a crisis of the sort that we're in. So where there is a greater demand for lawyers in one of our states that might be especially hard hit because of the coronavirus and might need greater access to lawyers and to legal services, matters are made extremely difficult by the fact that you have to be a licensed lawyer in order to provide legal services in the state, subject to some exceptions. So the point here is this: we are seeing serious interrogation and review of that regulatory regime, and it's about time. And some of that interrogation is on a short-term basis, emergency suspensions of regulations in order to deal with the coronavirus. But there's some reason to believe that those changes may become, who's to say if anything in life is permanent, but may go beyond the crisis. In the areas in which I spend most of my time, which is legal education, we're seeing that happen with respect to, as we speak, with respect to choices and decisions that are being made by the state bars in various states about licensing new law graduates. So things like the delaying of the timing of the bar exam or moving the bar exams online. I'll be interested, and this is more of a question for your audience, Pepe, than it is for me to offer, but I'm interested in what's happening in other countries, whether we're seeing other countries suspending their licensing requirements, doing different things in terms of the examination, using technology, providing maybe what we sometimes call in the US the option of a diploma privilege, which is, say, automatic licensing into the bar following graduation, because taking a bar exam in a big room full of colleagues is becoming unrealistic. Self-regulation's limits. Anyway, I'm spending too much time on this. Let me just bring the point to a close by saying we are seeing significant regulatory reforms underway, and we very much would benefit. We in the United States would very much benefit from the input and recommendations and data from other countries to see how we can make some progress. So again, this is just to make the point that we're seeing innovation happening in other countries as well. We can certainly come back to that. Now, finally, and I'm sensitive to the time here. I want to spend the rest of my time here talking more specifically about these issues that arise in connection with the COVID-19 crisis and legal issues. Well, the legal issues are myriad. I have the opportunity, I should have mentioned this in my introduction, I have the opportunity to teach a course. I've been teaching both at Northwestern and in MOOC form, in an online access, a massive online open access course through Coursera, a course on COVID, law in the time of COVID-19. It's an impossible course to teach in many ways because the legal issues are extraordinary. They're extraordinary in Mexico, in Europe, in Latin America, in Asia, and the United States as well. And they span a wide spectrum. No one can be an expert on any, and if there is such a person, it's not me. But what I can touch on, and I do touch on in the class, is a wide range of legal issues that have become extraordinarily important. Every single day, new issues arise as a result and as a consequence of the public health emergency that we're in, both in the United States and abroad. And here are just a few examples, an incomplete list of examples. Governmental regulation and civil liberties. The tension that exists when the government exerts extraordinary powers to shut down big parts of the economy, to require individuals to shelter in place, to impose severe limitations on the ability of individuals to travel outside their homes, outside their municipality, outside their state, and certainly outside the country. So in the United States, in a nutshell, most of the government's powers to issue the most far-reaching regulations on individual behavior and travel stem from something that we call the police power, which is in essence the power of the government to regulate and regulate behavior in order to protect health, safety, and welfare. It's an extraordinarily broad power. And an important United States Supreme Court decision from more than 100 years ago, from 1905 to be exact, when we had a different public health crisis and pandemic. And the government, the state of Massachusetts, had required individuals to vaccinate themselves, to get vaccinated. And so the question was, is that requirement of a mandatory vaccine consistent with our constitutional rights and liberties? And what the court answered in that case, and it remains good law 115 years later in the United States, is that in times of public health emergencies, the government has extraordinary powers, and that civil liberties must be considered in light of those powers. They don't dissolve entirely. That's not what the court said, but they should be understood. The civil liberties should be understood in the context of these public health imperatives and this public health emergencies. So the tension between strong governmental power on the one hand and civil liberties is acute. It's acute in the US, but it's not unique to the US. Of course, courts in other countries and other systems are negotiating and navigating this tension between governmental power and civil liberties. And that issue is brought into sharp relief in the case of this pandemic. There's also significant issues involving the assignment of authority among central and local governments. And yes, it is true that the United States system of federalism makes these issues not unique to the US, but of particular salience here. But these issues arise in connection with other countries. And so, you know, the central government in Mexico has an extraordinary range of powers, to be sure, but Mexico City has a profoundly important and powerful municipal government, right? And not to mention the states in that system. I'm by no means an expert, far from it, in how those tensions are navigated, but I know enough to know that there are constitutional issues that arise in connection with governmental regulation and civil liberties in Mexico, as there are in Brazil, as there are in the United Kingdom, even Singapore, a highly centralized state. Well, maybe Singapore is a bad example. That really is much, probably the closest we have to a unitary state with respect to that. I should say, even in Korea and in other countries, and in Italy certainly, that have dealt with these issues, there are tensions involving the assignment of authority. Law in the public health ecosystem, a range of issues, everything from the utilization of telemedicine to provide a greater access to physician service, to drug licensing and vaccination and what requirements should go through, are issues that arise in connection. Contract law and the like, contract and insurance, employment law, tort liability. We can talk about some of the details of these issues, but I just want to frame the larger set of issues. Enormously important and novel legal issues are arising. And while we have in our respective legal systems the capacity to engage in novel forms of legal reasoning and utilize more creative techniques to deal with new issues that arise, these issues are coming so fast and furiously. The economic consequences are extraordinary. The impact on the functioning not only of economic life, but of social life and individual life are so unbelievably profound that it represents this massive imposition on our legal system and on legal practice. Take just one example out of many. In the US and in other parts of the world, we are seeing that this pandemic, this public health emergency, is having an especially acute impact on the elderly. And so as a consequence, an especially acute impact on elderly citizens in all of our countries who are in assisted living facilities, nursing homes, or whatever the analogies are in other countries. In the United States and elsewhere, we have legal rules and regulations that govern such facilities, but that have proven woefully inadequate to deal with the myriad issues that arise. So, for instance, in some of the debates currently happening before the United States Congress involving economic support for various states and localities to deal with this public health emergency, there's been an enormous effort in recent weeks and in recent days to change the rules governing liability of these nursing homes and other facilities. It's come up in the context of cruise ships. It's come up in the context of bars and restaurants and others. The basic argument has been, if you provide extraordinary help to the economy, it has to be accompanied by, and by the way, not only extraordinary financial help, but significant easing up of regulations. So to allow bars and restaurants and companies and stores to open, it has to be accompanied by a shielding of liability or immunity, or else businesses won't effectively be able to be opened. Just imagine the liability consequences on companies for that might be sued because individuals get sick, given how little we know about how inadequate is our knowledge about the transmission of disease. So, look, these are issues that bear upon legal practice in important ways, but that lawyers need extraordinary help in navigating. I have just a few minutes left because before we open it up to questions. So I want to mention two examples in closing that are both COVID-19 related. One that's been very much on my mind and on the minds of others in recent weeks has to do with the issue of testing and contact tracing, right? So you've heard it's, of course, many countries are further along than the US in this. There's no doubt about that whatsoever. I wouldn't say that countries have figured this out, but they are further along in the evolution of this issue. But what we're struggling with in the US is basically this. How can we assure, as we gradually and steadily reopen our economy, release these shelter-in-place orders, as a number of countries have already done, How can we assure that we have a good sense of individuals who are infected or who might become infected, and make sure that they are tested? It's a big part of the issue, right? Testing, but also they're traced so that we know how they interact with folks in society. It cannot be, we can all agree on this, it cannot be that we can have an indefinite shutdown or lockdown, right, on businesses and individuals in their homes because we have difficulty tracing them. The tracing issue is an issue, I want to make this point, both of technology, also of business performance, and also of law. It involves not only the utilization of a variety of forms of technology, the development of apps, GPS, satellites, all the kinds of technology that can bring to bear on this, but there are also profound issues of privacy, right? I say privacy 1 and 2 simply to illustrate the point. There's the question of whether individuals will subject themselves to the use of technology that will report where they go, who they interact with, you know, who they visit. There's the issue of just the surveillance issue. But there's also the issue of what you do with the data that's being collected, right? Public health data, very sensitive public health data. And there are profoundly important rules and regimes of privacy. There's the GDPR in Europe. There's various privacy regulations that, of course, exist in Mexico and other countries in Latin America and as well. There are healthcare records protections and all of that. How can they be reconciled with the imperative of engaging in various contact tracing? Now, I have no profound answers to those questions. Those are very difficult questions. My own modest contribution to this debate is to say this again, is that the figuring out solutions to those problems, which we have to figure out, requires the active participation of lawyers, of business folks, and experts in management and employment and all of these areas, and also technologists who are working collaboratively to work on systematic solutions. And to beat this drum that I started out at the beginning of this presentation, that requires the interface among law, business, and technology that is so absolutely critical as we think about legal practice. The second and last example I want to mention that I know is on many lawyers' minds anyway, I won't. In fact, I'll stop the share and get off the slide. Is the issue of remote working. So we all, you ask a lawyer now, and he or she will say the following. Repeat themselves. Of course, the world's going to change. We're finding ourselves engaging in remote work. That's going to stick. So that even after the worst of the pandemic, lawyers will get used to engaging in different forms of work, and maybe we'll see a lot more telecommuting. Maybe we'll see a lot less travel. Now, I'm not a practicing lawyer every day. I have no great wisdom to offer, but like Professor Lynn and I, we've both talked about this. We hear this over and over and over again. The world's going to change. It's not going to go back to the way it was. Well, but how's it going to change is the important question. For example, will we as a society tolerate a world in which the lawyers get to stay at home and telecommute and work remotely, but all of the supporting staff and individuals, they need to get on the bus, get on the subway, get on public transportation, travel these many miles through Mexico City traffic, which is not that great last time I checked, and go to work, to be in the office so that the lawyers can engage in telecommuting. To say that's a social justice issue is to put it mildly. So there are social justice components to that. There are economic components to that. There's also the question of what remote working means. Does it just mean hitting the Zoom button and me and Pepe talking to each other on Zoom rather than meeting as we might in an office? Well, that's remote work, but that's not particularly ingenious or creative. The question is how we utilize these technologies to engage in these kinds of work. So I don't want to answer the question as much as throw out that question for consideration. How should lawyers in wherever we find ourselves utilize technology to think much more constructively and creatively about different types of work, different techniques of work, and engagement in different ways? And last point, what would we be giving up by doing so? as tempting as it might seem to say we're going to move to a world in which we don't have to go into the office, we can work in our pajamas, we can work from the privacy of our home, we can engage in that, we lose out on the connections, on the human connections that not only are important for us as individuals, as human beings, but have also been important to us as lawyers, engaging with clients, appearing before humans as judges, and all of that. So we run the risk of embracing remote work without knowing what are the costs and consequences on the way of behaving. So I think I've met the obligation, not the obligation, the duty of staying within an appropriate time frame, Pepe. So let me pause there, and hopefully we can use the rest of the time for conversation and for questions.
Perfect. Thanks a lot, Dan. And so guys, in case you have any questions to Dan, please just write it down on the chat and I will open your microphone so you can ask the question directly. But on the meantime, Dan, we can talk a little bit further on that last point. Well, in my opinion, I think one of the things that is going to change is that, well, home office right now, it's something that we were forced to do, okay? But I think that living in a chaotic city as Mexico City, or people from Sao Paulo, or people from New York City, law firms are going to be more open to let their people to work from home, because like in Mexico City, one of the worst things about traffic is that you lose around 1.5 hours to 2 hours every day on traffic. This means like around 10 hours a week, 40 hours a month that can be used for anything that can add value to your clients. And I think that will be one of the first things that is going to change. And also maybe, I don't want to say unnecessary meetings, but maybe clients right now will, I mean, obviously in-person contact still very important in order to treat the clients. But I would like you to comment about what do you think will change, not just in the legal profession, but also on the academic way. Northwestern, like what you've been doing with Delina also at Northwestern, it's incredible. You're pushing legal innovation very hard, and it's something that I admire. Here in Mexico, we still not that. There are some people that are pushing legal innovation, like in ITAM. I have a friend who's actually here. I think he's asking a question, Angel Sumano, who are developing legal boot camps in other universities, as Universidad Panamericana. But what would you say has worked better at Northwestern that maybe universities here in Mexico can learn?
So it's a great question. By the way, I couldn't help but notice someone on the chat form when you were talking about 1 to 2 hours suggested that's an underestimate with respect to Mexico City traffic. It says
yeah,
2 or 3 hours. But I'll let you guys settle that debate. But I take the broader point in terms of the inefficiencies that are created by the requirement. So a brief comment on law firms and then shifting to law schools. I think you put your finger on it exactly. It's not that all of a sudden in-person connectedness and meetings will vanish and travel will vanish. I suspect none of us think that will happen. There'll just be more of a scrutiny, right, on the necessity of in-person meetings and in-person engagement. And there will be a core, I expect, in which remote will not substitute for that. Again, the whole debate about whether online courts will persist, and so that we see these folks oral arguments, remote and all of that. But does that mean that we won't see in-person courts? No, I expect there will be not back to normal, but still a core of the necessity of in-person. And I think that your point about inefficiencies with respect to travel and all of that will be salient again. Law schools, boy, we're just really thinking through this. So in connection with COVID-19 in particular, as you probably know, and frankly, I'm embarrassed to say I don't know how this was handled in law schools around the world, but in the United States, almost overnight. We, in around the middle to late March, we shifted to entirely remote teaching. We obviously were sheltered in place. Our students were. So we turned on our Zoom technology, and we got through the rest of the semester in an online format. As Dan Lina and so many of us have been talking about at our schools, and these conversations are underway at other schools as well, the question is what the future holds. Certainly the short-term future, and that is, can we return and will we return to a more residential format in the coming fall? And I think, to be honest, we don't know the answer to that. But the more interesting, that's interesting, but maybe the more long-term question is what this means in terms of delivery models of legal education and education generally going forward. So you asked about innovations at Northwestern. I think it's a two-way street. I think we need to be attentive in American law schools to what the best practices are in education, legal education in other parts of the world as well. And we also need to collaborate and find out how new technologies can be utilized. I feel very strongly about this point. I don't think that, as much as I've cherished from the beginning of my education, my career as a legal educator, the in-person connection and the residential quality and the ways in which we can engage with our students and our colleagues as human beings in an in-person format, we have to realize and recognize that education can be delivered in many different modalities. And in certain urgent circumstances, like the public health emergency that we're in, we need to be creative and imaginative at developing new techniques and tactics. And technology can be very helpful to deliver legal education in a remote format. So I don't think that we serve, and this is to any educator, legal educator throughout the world, we think we serve our students, our current students, our prospective students well by simply saying, this sucks, this is terrible what we're having, this is clearly a second best solution to a public health problem. We need to roll up our sleeves, figure out how we can develop greater techniques of online instruction, retool ourselves in important ways in order to accommodate the crisis that we're in. And at the other end of that crisis, figure out what worked especially well, what didn't work so well, and help improve our educational delivery going forward.
Perfect. So we have a question by Luis Gutierrez. I'm going to open your microphone in case you want to ask directly with Dan. And Luis is asking how we should implement the technologies in our law firms, thinking on a specific solution for our practices, such as custom law, tax law. Do you have any recommendations on that, Dan? Or Luis, would you like to add more on your question? Your mic is open now.
Again, let me give an answer at a certain level of generality, which will be, and that is certainly law firms on their own initiative, and with the pressure, I think is a way to put it, from clients, should be very actively looking at technology and using technology across a range of practice areas. I don't think that, from what I hear from talking to many, many lawyers, there's something that is unique about litigation that requires greater use of technology that's distinct from transactional practice. Obviously, different practice areas have their different needs, but whether you're practicing in intellectual property, competition law, tax law, or the like, there are many technologies available. There are many vendors, right, that compete with one another in a healthy way to urge the use of their particular technologies. And lawyers are very savvy, by and large, at evaluating the smoke and mirrors, as it were, of certain technologies and others. But I think those technologies should be carefully scrutinized. One other point, though, we need to be aware, as I know you all as practicing lawyers are aware, that not all firms are the same. Not all firms are as well resourced. That's also true of law schools. So what might be desirable and possible for, take an example in the US of Kirkland and Ellis or Skadden Arps, or whatever the analogies are in your country, is a massive law firm with hundreds or even thousands of lawyers, versus a law firm of 5 lawyers or a boutique area firm, or certainly a legal aid organization, is going to be very different. That's why it's important that the marketplace for technology be sort itself out, so that technology is available in appropriate forms and fashions, regardless of the size and the resources available to a particular law firm, because this is about providing client service, and different firms will have different demands placed on them for the availability and use of those different technologies.
Exactly. So I just want to jump a little bit here, and it's not like asking which technology works better, because if you do that, you're starting by the answer, and the question will be like, what are your pain points? What are your necessities? And now, once you want to look around which kind of softwares are around the market that can help you with that, so you can ask the vendors, can you do this? Can you do that? What are the prices? What are the different prices? Because usually, I mean, most of legal tech softwares, they have different costs. One is licenses, and the other one is implementation. And the implementation, it works like any other kind of consulting services, and it depends on the complexity of what you want to do. That's gonna it's, of course, it's going to be a little bit more expensive than if you have a very straightforward project. So, and as you say, it's not the same having the same funds as a huge, massive law firm such as Skadden or Kirk and Annalise. So you have to be very, very centered on what are your bottlenecks in your operation in order to take the decision on that.
I think that's exactly right. And I want to add a note too, and I've learned a lot in this. I continue to learn a lot from my colleague, Dan Linna, who's on this call. He would want me to say this, and I will say this. It's very important that we develop data that enables us to make assessments of how the technology has been used successfully and not successfully. That's something that certainly in legal education we're not very good at, and law firms are still working hard could become better, which is how you make the analysis and assessment of what's been successful and what's not been successful. That is an imperative when you go down the road of using technology for your own use and for your clients' use.
Right. So I'm going to open Dan Linna's mic in case you would like to add something. Oh, it's not working.
He'll say it better than I probably did.
There you go, Dan.
No, this is all very interesting, and I agree with everything Dan has said. I think it's just a quick anecdote. I listened in to a webinar earlier today that Bob Ambrosi did with some leaders of some large US firms, and they made the point over and again as well about the importance of strong leadership and management, including project management, which Dan mentioned earlier. And I mean, I think that, to your point, Pepe, you were talking about kind of jumping to the solution, and part of that problem discovery, right? Like really making sure you understand what is the value proposition for the client. Do you really understand your workflow? And too often, or even on the project management topic, it's interesting. There's too often where it's hard to convince lawyers that project management will actually help them improve legal services delivery. I think we have plenty of data and case studies to show that now. But even then, sometimes people will say, well, what technology do I need? What software do I need to do project management? And sure, technology can help, but for the most part, it's about the people and having the right culture. And those are the really hard things to do. The technology is really important, of course. It can really, really advance your efforts. But what we're hearing more and more, and I think what we're seeing, and we will see through this crisis, is that it's not just the firms that have implemented the technology, but the firms that have really thought about how to build the right culture, how to empower everyone in the organization to think about how to keep improving and use strong project management, and leadership techniques within the organization. So absolutely, that's what I'd say. That's what I'd add.
Hear, hear.
No, that's perfect, and I totally agree with that. Dan Lina also talked about that in one of our first tech talks on January, and I think like project management should be like one of the first focus for law firms, because that will help law firms first of all to train their more junior lawyers, because now they will know exactly what are the process for different cases, what are the times that it takes for each step of a trial, each step of an M&A process, of a due diligence. And if you have everything there as a map, it will be easier for you to train your lawyers and to, well, not to avoid mistakes, right? Because if you have everything well traced and monitor, it will help a lot to your lawyers, and also you as a partner, to be aware on in which part of the process you're working right now.
Sure. Pepe, if I may, I want to reinforce a point about collaboration I made before. Now,
yes,
when I talk to law firms, and when I talk more often to law schools about collaboration, the instincts, of course, the antennas go up. You have in what we call antitrust law, what most parts of the world call competition law, which rightly, puts limitations on legal limitations on the ability of organizations to just get together and obviously fix prices or make, enter into agreements that that ultimately restrict competition and harm consumers. So we know all that, but that's often invoked as a shield against collaboration and community information sharing, and that's really quite unfortunate, because there is enormous value to consortia of legal educators and law schools getting together to talk about best practices and innovation. There's enormous value to law firms getting together, and partners and people in firms getting together to talk about technology and the best use of technology. Yes, there are conferences, there are meetings, they're often organized by vendors who are there to, to help urge firms to buy their products. That's great too. But I'm talking about the sharing of data and the communication about information. And even in this period in which we're sheltering in place, and in the future period in which we might be reluctant to do the kind of international travel that we saw in the recent past, there's still enormous opportunities to share information and perspectives across our firms. We worry about the competition constantly. We all do, right? We don't want to give away our trade secrets. We don't want to give away all our great ideas. But that can be very exaggerated. There's enormous value to learning from practices that work and have been successful in firms across borders that would really help in figuring out what's the best use of technology. And I think that's been underutilized for a lot of reasons in the last years and decades.
So Dan, you raise your hand there.
Sure, I have a question. Dan, you're an expert on administrative law, and if you read kind of the clickbait headlines when they talk about AI and law, there's this hysteria sometimes about robot judges and how terrible that would be. And even some of the academic writing tends to be slanted that way. But there's another batch of writing about this that talks about the ways in which machine learning could help us understand more about the way judges make decisions, the way administrative decisions are made. And in a lot of ways, those tools could bring much more fairness to that whole process. And we see the opportunities here in the US, but also we could think about other jurisdictions where we may worry about corruption or inconsistencies. And I mean, what are your thoughts on how we can make the most of these technologies, and maybe do we need to change the narrative around that? Or I mean, what do you think?
So you're appealing to my strong interest in this area. So a few thoughts. The reason why we have so much administrative justice, that is the reliance and the use of administrators rather than ordinary judges in not only in the U.S. but in many parts of the world, is largely, broadly speaking, for two reasons. Number one, for efficiency reasons, is that we simply have so many legal disputes, so many issues to be resolved, and that can't be resolved by relying on elaborate judicial processes. Criminal justice is maybe, let's put that to one side as a special case. In the area of civil justice, we need to rely on administrators to really resolve these disputes, whether you're talking about government benefits, veterans benefits in the US context, so many others. So there's an efficiency need. The second is that we believe that administrators have expertise and that many of these decisions involve whatever we think of the adversary system and the contest, that they involve the deployment of experts who can deal with these range of issues. I think those are fundamental precepts that lend themselves to a much greater use of technology and even machine learning and artificial intelligence to help resolve those disputes. So you mentioned the issue of bias. We worry about, in all of our countries, judicial bias entering into the picture in the resolution of disputes. And we have safeguards against bias. The adversary system works against bias, or the inquisitory system in some systems that's utilized to try to cabin that bias. We have scrutiny of our judges. We have public opinion and all of that. But at the end of the day, these are human beings, flawed human beings that have biases, implicit biases that we know about, lack of information. There's a very famous study out of Israel that some of you may have heard of that actually shows a different outcome in cases depending on whether the judge had breakfast or not had breakfast at the time. That's a frightening study, right? That judicial outcomes can be measured. But we're talking about human beings with all of those. So when we can utilize technology, you can call it robots hyperbolically, but utilize technology to reduce the source of those biases, that's enormously advantageous. The question is, there are many questions that come along with that, but many of them involve how realistic is it to suppose that algorithms can be de-biased or can guard against biases in that part of the process. How much will individuals tolerate having their disputes resolved through iterative decision-making and machine learning, rather than having, as we say in the US, their day in court, right? So there are enormous issues and challenges. But I always come to the bottom line, and I mentioned the example of Brazil. When you have a backlog of 70 million cases in just one area or in the United States in the veterans context, and I know Mexico has some enormous backlogs in particular areas, then the question is, as so many folks have observed, not a species of justice, but whether you have any justice whatsoever. And I'll flip the question you asked, Dan, on its head and say, if we don't utilize technology and we don't utilize machine learning and we don't utilize, yes, bots where appropriate and other kinds of techniques, we're going to face an increasing unavailability of access to justice that simply will not be able to be resolved by simply appointing more judges, by having more pro bono provision of legal services, or what have you. So I think that die has been cast. We're going to use machines and we're going to use machine learning to enhance administrative justice. The question is how we best do that consistent with our legal culture and our legal values.
Great, perfect. So guys, if there is no other further questions, well, then I would like to thank you again for your time. It's always great to talk to you again. And well, also thanks to all the people that came here to listen to Dan. Thanks a lot. And we'll continue with these Tech Talks. Dan, Lena, hope to see you back either here in Mexico City or in Chicago.
we were delighted. Thank you for putting this together, and I look forward to working with and joining with all my friends in Mexico and elsewhere. And thank you, Pepe, for organizing this just most interesting series.
Thanks to you guys, and stay safe. Take care. Thank you a lot.
Thanks.